NPP for Sama Jumaniso Godfred Dame Attorney General Sama Jumaniso Sama Jumu bread fool Honorable Kennedy Akompre kwa Agyapong kachire mo ena mwantie Prophet Kennedy Akompre kwa Agyapong kachire mo ena mwantie ene Ghana fo se mahunu NPP fo ye ka mwantie no 2024 ena mo behunu Moma Ghana eni wiase nyina hunu se Honorable Ato Forson eye kromfo Honorable Kennedy Akompre kwa Agyapong kaye Mwantie Ode Ghana fo yenko na yenko tie Prophet Messiah Kennedy Akompre kwa Agyapong.
Things have gone on. But honestly, I'll be frank. Me nim sa some no court here. But I disagree. I disagree with Ato Forson Diano. Yes. Now truth will kill me because Sawusi will be a minister of finance. Nese ministry be edine yabano establish LC manual. Now kasa dia eni emu ministers na motiwa na mu heli sayid. Mu hwani.
Ana we bia bibi wo mu anwunim.
Well, but I'm telling you, my reading kakra and I'm just saying in principle Sawuka James said Ato Forson causing financial loss to the state because he established an LC for a ministry. It is not his responsibility to check, say, anyone buyer Nasama. It is the responsibility of that particular ministry. I will establish an LC on his behalf to check.
And on to the BSS of any.
What you say? Media, Mrs. Who you sue and no as causing and causing financial loss to the state. I disagree.
Okay.
Me must state my position. Me so watching me, but
oh, there be
maybe
anya facts ni nyina na available.
I know the facts. I know. What you say? I disagree because yes, sir, ministers, you are not even empowering anybody to sign anything because they will take a clue from Ato Forson. It is a whole reform, sir.
But unfortunately, no, Ato Forson is in court. He has not been sentenced. So they are okay.
Yeah.
I think so. Obey given the case.
Right. I'm saying or court to a young canopy. But me no but my state me position means no. I can't. Any echo. I am not against Obi Awam this can no. But the cry be alpha so. Me I've always had a problem with causing financial loss to the state. So I charge it. Honestly.
Very fantastic. Honorable Kennedy Akompre kwa Agyapong. Or say, na true go kill me. Honorable Kennedy Agyapong ne nokore. Ena ahye me ma. Ama me nso so me ka nokore saa. Na honorable nokore ntumi nku. Wo ka nokore wo nyame mu a ede papa. Na nka hwe me abofra ketekete wei a me ne hwe. Na NPP a whole political party e wa ban mu pam yakume bo amanfo pa de menam enuru so nanso hwe afi na Nyankopon ye mekese nokore ne sede medwen nipa ho se nipa hawo ye me hawo nipa bre ye me bre na menhwe de medie na medwen nipa ho NPP for me say me na me ye de David ena moye Goliath na ye beji Ghana si ho honorable Ato Forson case no is a test case for NPP say NPP semopeo ye ko opposition 2024 and no prophet no miracle because Ghana for ahiafo ne wona wo ho kire wona wo suo wona wo nwuma guo wona wo businesses won sika ahye Wamusun eye Nyankopon sun and God has listened to them. Me say NPP be win power Jise bia na nyankopon abufu hyew ewo Ghana fo yeso na nyankopon pese Dr. Alhaji Mamudu Bawumia obepa na hye yen Ghana fo mi bisa NPP fo why na akoso financial loss to the state eye honorable ato Forson anase eye NPP fo Godfrey Dame makwa hye Ghana sika kwa mama Ghana fo nyina hu se honorable ato Forson ye kromfo ma hu se nyankopon agumani mu ase. You see, at the end of the day, muna mu wa ban mo, muna mu control court, muna mu control the judicial system. Na Godfrey Dame, obi a wako suku, a waso ye lawyer pani, attorney general mua. Na wote ho, wantimi anyusu wa adwen, Kennedy akompre kwa Agyapong a onye lawyer, onko law school da, oni ene law background, ekura timi hu sa same way enkosi aga munyai. Na wo obi a wo se wako suku mo sori abrofo akese a reme mo kakura ye ntiase ne akaka bensem ene hweba bia dollar nam mo hwa no nye ensemhunu ni sika seye ne sika hye ene wo se wakobo o man ne kakwa ekosi sen na ye ka na MPP fo bi mo sori amosem ye fo soldiers mo ma ye nka. I don't know about Agyapong kaya no. O say na true go kill me. Na dokore ya making NPP fo be di me atem. Ye beka mo atem ni die de mo amudi atem no na nyankopon hyiraye na mo anim guase no afi kura na eye kese. Godfrey Dame die na asia wontimi ko prosecute Cecilia Dapa. Cecilia Dapa kromfo sa no. Na me catch no bibia. Me say me the full expose eba. Nana Adodanko Akufo-Addo $50 billion. Me say $50 billion. Monton Krama interior minister former greater Accra minister no kra friend saying Monton Krama no so say ya shamra wa Ghana ha what na social media so kan asem na enye no kra yetimi chew e prosecute na Monton Krama na Adodanko Akufo-Addo na Monton Krama Cecilia Dapa na monton krama ya mame frima opare ene ayi kenoforiata de ene de isua just $200 million. We say I am bringing the full expose ye ka akromfo a the bunch of thief krono na nkasa the thief is Nana Adodanko Akufo-Addo from the Jubilee House. Me say minsuro bia wo krom ha mo MPP fo no de minsuro bia mo te se atentenhuo e wo minsam mo MPP fo no me say mo te se atentenhuo akromfo awudifo. I am daring you people, come and challenge me. Samo na mukura mra no mo na tumi kura mo. I am daring you. Me say Nana Adodanko Akufo-Addo frema opare Cecilia Dapa kenoforiata mo ya kromfo wo ayi Godfrey Dame akromfo no omoto backyard. You can prosecute them. Dear Nasia Cecilia Dapa kromfo ye kwache dollars e wo nem passe case no monya the foolish case. Why is Attorney General not interested? Nana Adodanko Akufo-Addo monso menhwe akokora yesi akokora de onfa sika nya hwe. You are coming to protect the public purse. And here ne. Nana nyame kasa kireye. No mampani dada akofo de. Hey, mampani dada akofo nyankopon hyirawo. Obuo nie. Woto ye nkrabo. Ena aso den yantie. Se yetie ya. And here no. 2009 MPP lose ye nyina sana nyankopon kasa kireye. 2012 MPP lose ye nyina na nyame kasa kireye. 2016 na nyankopon se aye de adwa ne ho ache dodo ena enne hwe Nana Adodanko Akufo-Addo kromfu techi amwa na me say I am daring more MPP fo no mo se mo ye supporters ne hwan no na den na mo prosecute me mfa me nkwa court adan na mo mfa mo national security ne mfrɛ me MPP fo ana mo nte de America no mate atwam because na do me wo hona me papa ba ko bi frɛ me o frɛ me na o ye doctor and or the two video say Frank my fan two video na oye ni business ni go bi me the information bi better and me the two video awanyini o wanyini pa doctor muwa na nanim nyina fubie na badwe nyina say ha Frank na usasa akura kete sana wama NPP fo ejagu omu chemsa no ono prade a o se akura kete sana wama NPP fo ye bresa no NPP fo me say se mo ni asempa na mo nya mo kro no a me say me nokore and me nokore no efre urade nyame na ehye me every information asem bia meka bia enya me pe na me de ka o eya urade na ehye me asem se na se minima me wo na nyankopon asoma na bofo na wade information na breme sa na do dan kwa kufa do $50 billion ya me se me ba be expose ni me wo na the whole world investors no mo akasa na o de document ne sende me ebi wada na do ho do wo de me se ohun badwiru wo de tamu chuku me de baba ene wa hunu gofre dame mo NPP fo akromfo no muntumi prosecute omo na innocent otan hunu kwa because the economy no honorable ato Forson ene ye NDC for economic messiah oba be exposing yewura Dr. Agyapong Baumia on the economy ene economy na say because in 2015-2016 ye campaign based on the economy that time na economic messiah Dr. Agyapong Baumia enti se omo anche ato Forson am frustrating no a some of the megu kuremu no enti case yenye case na wo na nado danko akufu ado utumi ka kire attorney general say onhwe na on prosecute na yemfa no tumtem before the election 2024 election na nado nyame na atua woka wo krono a wabɔ no yede watum mo sɔre a wo se oye president nti oman no hye wo nsa de wo pɛ na wo ye ɛna kromu ha obia suro ɛna obia ntumi nka wa asɛm wo kromfo saa na nado kromfo saa me se na nado wo ye kromfo se wo na nado wo se meboa ne wo MPP fo no mo se meboa go and sue me. I am daring you people. Who gave you the power? Through my power, I gave you the power, and I have every right to criticize you. Kromfo na me nim so ye kromfo anka yamfa tumi ama wo dada yen Ghana fo nyina even what tumi adada nyankopon na ye nipa de na wontumi na adae what tumi adada nyankopon ye nipa na wontumi na adae ye kam me say ye beji Ghana si ho mo ka anwom na ya amede ba no ye nara ye na asasini ye na nanom di won moja na ji Ghana si ho me ne wo mienu de na ye ya to aso wo sori a wo party fo soja wo ye party communicator wo nim se ade enye wo so be defend enti de ye ya to aso ye nkontompo kro no aden na momma ya nwene se nipa na ya nwene se Ghana ni ene mahu honorable Kwaku Kwaten ose ohwe de NPP eye Ghana no a osuro daache enti se de aduro ache no ose Ghana daache ehu na se wankasamu anka nokra Ghana yen democracy no ebe break it down. What does that mean? Me as a political scientist, what it means is that there's going to be a war. Wona we NPP na wo se won kan okure no. I am telling you, and say musuro me say 2024 say NPP fo am fan okure na electoral commission. No mo ye omo adwen say omo wi abanum. There's going to be a civil war. I'm telling you. Because NDC will not sit down. Eti wona wo preach say abato no nya asundwie no kotu NPP akromfo ere isifo no fo se kukukuku ni jaya keka no ebejai se NPP fo anya krono no mo pese mo wiamu na entokwa no de eto ntwa da eti wo so ye sofo wo so ye motivational speaker wo so ye hwan se wo futuo bia na owo kasa kire bia ko kasa kire na nando danko akufu ado saka Agyapade book no they are working everything perfect eti omode omo say even if by death say Ghana ye moja mpo na omo behwie agu ho a omo beye bunkotu amofo say me di kan ba be ka kire mo say NPP is training some IT gurus omo de be wi abanum no omo ato journalists big journalists ya Ghana hanyina And this man won't me media for Babaka, a Kwame Chromaticus here, dear. As on the Sadia, I make an put there get. Yes, a Kwame Chromaticus here, Kissy Camano, Yatokasia Mano, yes, answer the Nuka Bruchy trips, say only defend the NPP. And now, to say Kwame Chroma, Nuko Pie, or say Ghana for bread. Na Ghana for yɛhwɛ yɛ asetram na yɛnyu ya agwen emfanto aba do wa gye MPP fo sika na didi sika na hye na yɛka na wo hiani wo na ho kyere wo no wo defend you didi yɛ na tem na me bi sɛ me aho kyere bɛn na wo me so e ka de medie mefra na we are for can worldwide for omotimi hwɛ me ma bi ka o we are for can for ade bia ni ho de me pɛ no asase so a me nsa nka na wo tie me no kura no ade bia du ho de me pɛ na me bi sɛ wo mfa mame me boa even mo politicians no ade bia du ho de me pɛ wo mfa mame on pese me je na me kama no tum but me se Ghana for every until se Ghana for be di Ghana for ho beto mo me nkama no we entum da na NPP ni bia so ntimi nyam foko NPP fo mo betra bia no God will strike you people down me si onua de amamia kuku duro na metumi kasa a me nsuro no ye nokore ne se de medwi nipa ho me nipa how ya me how nipa mane ye mama ne. My records go to NC College of Education. Me complete NC College of Education 2013. Go and ask. Students ni bia na mo friend minority leader. Lecturers no, tutors no. I say na akwa bempa na principal akwa gina baskum ha o ha ya adwesa. Omo to be catch them say, "Omo ma faili." And in training college, say tutors ni ka say obe faili. Obi a wako training college bi anim. And I told them, mo team ya mama failure ni D. And D no so mepe. Eno kura yentumi ankama no antumo. Yentumi ankama no antum. Wo da me se mo nko bisa mase NC College of Education from 2010 to 2013. Eti NPP fo no. Me ka no kure no akire mo. Gofre dame. Se mo wo obi a mo be prosecute no a. Eye mo ankasa Cecilia Dapa nke se mo prosecute no. Odo na River na se akosi sen. Hwe sika twitwiri die. Ekomu akosi sen. Look at unpopular policies and programs must say Ghana sika. Ghana na nado dan kwakufu adon ko abaye. Wabobosia 620 billion Ghana cedis. The only show off obetimi a kire free SHS. Free SHS so no 9.9 billion. Into that 610 billion no. Ewa he MPP for ewa. The only show off apart from free SHS with the MPP for Montrebe. Ghana for Montrebe the MPP for the boy Mohosa for hene. Meanwhile, from Dr. Kwame Nkrumah pencil, basic NDC pencil. A car Ghana boy in 122 billion. Nana nado nkwa just enuru 8 years you. What Bob Bessian kwa 620 billion. Untimi nchire bibia so. Na wo go Fred da me oti ho. Oti sa akro no we ho. Wosia chi ayi wosre apro emoa efirimu. Wose wo kwa akwaho obi sre. Na akromfo abuga pele mu a yewura John Dramani Mahama chi omugu mu no. Enye na nado dan kwa kufado ya na be yi omufirimu. Hwe yese wo wefo nsa na wahwe wo de ye nyina kromu ha na yedidi yewura John Dramani Mahama atem so ye kromfo NTC fo ya kromfo mo baaye ekosi sen ato Forson na modi mani asi ni so ene ye ne na me de me se 2024 no nyamema esu ene a Christopher mura fi oturumu no sa mura fi a Christopher mura fi na mekai mo na wo ye Kristoni na okoto wa ba ma Dr. Alhaji Mamudu Bawumi a ene ye memetena ha mesu biewo memesu se wate se yewura Dr. Alhaji Mamudu Bawumi a wo mo bia ade na onye ne mprempren na ode ye menche ho honorable ato Forson lawyer no wakasa Run the long and short.
the Attorney General called 5 prosecution witnesses. 5. At the end of the day, we indicated to the court that from what has transpired relative to all the prosecution witnesses, we believe that no case had been made against the Honorable Forson. The trial judge, in her wisdom, said she believed that a prima facie case had been made and that we should open our defense. Immediately we mounted an appeal on the ruling on the submission of no case, which appeal was yesterday, decided upon. Now, Randy, what for me interests me in all of this is that in the ruling of the trial court, calling upon us to open our defense, we obliged. And so you notice from the records that we called 2 witnesses to testify on our behalf, upon which we close our case. Then the second accused, Dr. Animana Sylvester, also opened his defense. But along the side, he became very sick and so had to go outside the country for medical treatment. The Attorney General later indicated that out of compassion, he was filing a nolle prosequi. But later, I will tell you something. Now, when they filed the nolle prosequi, it was left with the Honorable Forson and Richard Japa. And the rest of it is a matter of public record. So yesterday, the Court of Appeal, as you indicated, by the 2-1 majority, delivered its ruling. And Randy, I just want to read some portions of the judgment for our viewers. And those who have it, I'll refer them to go to pages 25 of the judgment. This is what the court said. I note that Mr. Markwe, he works at the Bank of Ghana, in particular said in his evidence, for whatever reason, that the first appellant instructed the Bank of Ghana to establish an LC in favor of Big C in the letter dated August 7, 20. Now, at the cross-examination of Markwe, we showed him the letter Forson wrote, that he should read where Forson instructed the Bank of Ghana. He then indicated on oath that it was an incorrect statement and that Forson only requested. How in God's name can such a person be considered to be a credible witness? So the court, this is what the Court of Appeal, at the trial, when he was challenged on the use of the word instructed, and in my opinion, he chose to equivocate on it instead of accepting it. In my view, this was unnecessary posturing because the first appellant did not use the word instruct, but rather requested in the letter he wrote. So these are witnesses that were coached. And this Markwe guy works at the Bank of Ghana. He saw the letter Forson wrote, never using the word instructed. But they wanted to create a certain narrative as though it was like, I authorize you to do something. And so they needed to insert the word instruct instead of the request. You do know that when I request you to do something, you have the benefit of looking around the circumstances and deciding not to. But that would defeat their case. So they introduced the word instruct as though it's an authority. It's a command. Knowing very well that was not. So the judge said, why in God's name would you do that? Now listen to what the judge said. Mr. Markwe told the court that the letter of 7 was on the letterhead of the Ministry of Finance and was signed on behalf of the minister. The letter was signed on behalf of the minister. So at this point, the minister on whose behalf the letter was signed is a material witness for you. They never called Setepe. And still managed to build a case that the Honorable Forson acted without authority. Whose authority? definitely his boss. So if you are alleging that there was a lack of authority, then you needed to call him to accept that he never authorized him. But Godfrey knew that there's no way he could proceed with that assertion. So, see what the court said. Mr. Markwe also said that the LC is not payment, but a guarantee. Now listen to what transpired under cross-examination by my senior Dr. Bamba. So you agree with me from the explanation of the letters of credit that the letter of credit in itself is not payment, would you not? Answer, yes, my lady. But the letters of credit guarantee payment. Question, a letter of credit guarantees payment subject to certain conditions being met. Is that correct? Yes, my lady. Question, therefore, it follows that if the conditions under the letters of credit had not been met, then payment will not be made. Correct? He said, no, my lady. It is only when the conditions are met that payment will be made. Now, guess what? The people Bank of Ghana reached out to find out whether the conditions have been made were Ministry of Health officials. They gave the approval that they have inspected the shipment, the pre-shipment, the equipment, and what we call it, the letters accompany the ambulances and others, and they are satisfied. They can go ahead and do the payment. Not at Forson. And upon all this, he was called upon to open his defense. Defense of what? Randy, defense of what? And so the court now reasons, my lords, the evidence also establishes that the witness told the court that the first appellant was not the applicant for the LCs, but the Ministry of Health was. Again, this is what transpired when Markwe was further cross-examined by Dr. Aziz Bamba. Quote, take a look at Exhibit A for A1. It has a column for applicant, does it not? Yes, my lady. The applicant herein refers to the entity applying for the letters of credit. Is that not? Yes, my lady. On Exhibit 1 for A1, the applicant is stated as the Ministry of Health. Is that not? Yes, my lady. Upon all this, the trial judge said, Forson, come and open your defense. That you authorize the payment. Look, you see, Randy, no Ghanaian, I repeat, no Ghanaian should be made to go through what Forson had gone through in the past almost 2 years. I say this with heavy heart. Because you see, when a prosecution looks like, you see, ours is to prosecute. It's not an inquisitorial system. It's adversarial. And he knows that. What it means is that at no point in time should an accused person be put in a situation as though he is guilty, but he must establish his innocence. And you say, Randy, these things that I've referenced were prosecution witnesses. Prosecution witnesses. So the court now said, the witness also told the court that the document for payment included issued LC and documents such as pre-shipment inspection certificate or label and insurance certificate covering all risk. When the cross-examination continued, the following evidence was further elicited. Who signed Exhibit 1 for A1? Guess what? It was signed by the controller and accountant general and the deputy controller and accountant general. So you agree with me that A1 was not the applicant in Exhibit 1 for A1? Answer. I did not get the question clearly. So Dr. Bamba repeated. The question is that A1, the Honorable Kesela Forson, is not the applicant indicated on Exhibit 1. Is that not so? No, my lady. The Honorable Forson is not the applicant for A1. And meanwhile, the trial judge says, come and open your defense. Now, see what the court said about Kweku Agyapong Menu, the person who went and reported the case to EOCO. Mr. Kweku Agyapong Menu also testified about the letters of August and this by the first appellant to request for the LC. I note that he initially said that the LC was requested without the notice of the Ministry of Health. But when he was confronted later about it under cross-examination, he accepted that his initial position was wrong. Mr. Kweku Agyapong Menu also said the LC is not payment, but a guarantee. Again, the following is a snippet. You have also served as the chairman of the Public Accounts Committee of Parliament. Is that correct? That is correct. So you have quite a working understanding of how LCs operate. Is that correct? Yes, I do. Are you aware, are you not, that the LCs are not payment in themselves, but guarantee or promise of payment subject to certain conditions being met? Now, guess his answer. That is so. This is Kweku Agyapong Menu. So, on what basis was Godfrey Dame now asserting that it was Ato Forson who authorized the payment? On what basis? And that is why when he said he is going to the Supreme Court, I said, why is the Supreme Court going to manufacture evidence for him? This is what your own witness under cross-examination said before the court.
Help me with something. So, if the case against the Honorable Ato Forson was that as deputy minister,
yes,
he was not authorized to sign those letters or that letter that he signed, and therefore he signed that letter, and the letter reads on behalf of the minister. What was the proof that was adduced in court to establish that indeed he did not have the consent or authorization of the minister to sign that letter?
No evidence. Nobody.
But is that not the case against him?
Exactly. Exactly. So now you see, sometimes the judge rather said the burden is on Ato Forson.
How? That an allegation is made against you that you didn't have the authority to sign. You don't have the authority of a minister. So prove that you have the authority. Is that what you're saying happened?
Yes.
Okay.
And you say
this judgment, did it speak to that?
Yes, he resolved it.
Okay. What did he say?
The court said that under our current constitutional arrangement and the jurisprudence that we know, criminal jurisprudence, first of all, the state is mighty. And so the burden to prove all the essential elements of the offense lies with the prosecution and not the accused. And so that invitation was like asking the accused person to assist the prosecution in his own...
Against himself.
Against himself. And that particular invitation offends the rule against self-incrimination. This is how the Court of Appeal resolved the matter.
But who made that assertion? Who accepted?
No, so I'm coming. Let me just read something to you. How the Court of Appeal went. It said further, by saying that Exhibit 54A1 had not been subject to cross-examination, and this Exhibit 54A1 was a statement Setekpe volunteered to Yoko that the Ministry of Finance asked for the LC to be established. That day, Dr. Bassett didn't come. So I cross-examined the investigator. So I showed him Setekpe's statement to Yoko. I said, who took this statement? He said, he did. Can you confirm the signature? He said, yes. So I said, okay, I will tender it to him. So I did. Then I asked him to read the entire statement. When the entire statement was read, the Honorable Setekpe indicated that the Ministry of Finance asked for the LC to be upon the advice by the then Attorney General. Right? So see how the High Court went about it. It says, my lords, in the first paragraph of my opinion, I refer to the quote that an accused person has the right not to be forced into assisting in his or her own prosecution. In my opinion, that protection afforded to accused person is anchored in the overarching principle against self-incrimination, which is firmly rooted in our constitutional law as a fundamental principle of justice under Article 19(2)(c) and the common law. The root of this principle is based on the presumption of innocence and the fact that the state, as the Hobbesian Leviathan, which prosecutes an accused, has more resources than the accused. In other words, until the prosecution establishes that there is a case to meet, an accused person should not be compelled to testify. It proceeds. As counsel for first appellant correctly observed in his submission, in the case at the bar, the law under which the first accused is charged does not impose a burden on him to explain whether he had an authority to act. He continued, he was not charged with a strict liability offense, but with willfully causing financial loss and misapplication of state property. It is therefore difficult to reason with the trial judge on her decision that the first appellant must testify to explain whether he had authority to act. He continued, further, by saying that Exhibit 54A1 had not been subject to the cross-examination. So after I introduced this Exhibit 54A1, the judge in her ruling then said, Setekwe has not been subjected to cross-examination. And so for that matter, she will not regard the statement the man volunteered to Yoku. That was tendered without objection. Shockingly. Now, so this is what the court said. So, further, by saying that Exhibit 54A1 had not been subject to cross-examination, and that the first appellant should rather establish that he had authority to act, the learned trial judge, by implication, is saying that she had heard the prosecution witness, but she must also hear from the first accused in order to decide. I am of the view that that is tantamount to shifting the burden on the first accused to prove his innocence. It also implies that the first appellant will be found guilty if he fails to explain that he had authority to act. Randy. So, there's another portion that I just want to read. My lords, it is true that at the close of the prosecution's case, the guilt of the accused person is not supposed to be proved beyond reasonable doubt for the purpose of submission of no case. But the law requires that the prosecution must provide sufficient evidence, as per Section 11 of the Evidence Act, said that the evidence should be capable of convicting the accused if he or she does not offer any explanation. If there is no evidence to support the charge laid against the accused, the court must hold that no prima facie case has been made out and that the accused is entitled to be acquitted and discharged. Like you rightly pointed out, Godfrey Adame called 5 prosecution witnesses. At no material time did any one of them say. What they rather sought to do is that Setekwe didn't say, but said the ministry authorized the establishment, requested for the establishment of the LC. If the ministry did, and you do know that the Honorable Ato Forson was the deputy, in God's name, why would you say that Setekwe didn't do otherwise? Setekwe is a living being. He's alive. He's here. If you believe in your story, and it is his authority that you are denying, what do? Call him to come and assert that I never authorized. Then Ato Forson will now have the responsibility of showing whose authority he acted with. Now, you see, something curious happened. The letter of 7th August that the Honorable Ato Forson wrote, requesting the LC, he copied Setekpe. So,
and did he sign on behalf of him?
Yes. Okay. So when the investigator came, I asked him, in fact, we queried my men first, that this letter, is it possible for a deputy, you were once even a deputy minister, is it possible for a letter to be written on behalf of your board? He said it's a normal thing. So then a question was put to him. When the letter is written on behalf of your boss and he did not sanction it, would you not be subject to query? He said that should be possible. From 2014, when Ato Forson wrote that letter, to the time you are testifying, has there been any record of an inquiry against him? He said, not as he knows of. Upon all these matters, Ato Forson was still asked to open his defense. Randy. Now, you see what the judge said. My lords, as stated earlier, there is no link between the evidence heard and the element of the charge for the court to hold that a prima facie case had been made. Consequently, based on the evaluation of the evidence laid before the trial court and the submission made on behalf of the first appellant, I am of the view that the prosecution failed to provide sufficient evidence that meets the threshold of connecting the first appellant with the offenses he's charged with and relates to the ultimate of proof beyond reasonable doubt. This explains why I take the position that the trial judge erred in her application of the law in calling upon the first appellant to open his defense. Curiously, I want to read this other portion. You know, Godfred had been talking about lack of parliamentary approval and what have you. I have never seen in my life a dishonest attorney general like Godfred. You called 5 witnesses to come and build up your case. Now listen to what the court said. First and foremost, I have no hesitation in dismissing the prosecution contention that the request for the LC was reckless and criminal because it did not receive parliamentary approval. The idea of parliamentary approval was never part of the prosecution's case, as it never found part of the particulars set out of the offense for which the first appellant was charged. With respect, it was an afterthought.
Really?
Yes. I will not place any weight on it. Regarding the court's position on the ZAT exhibit, with the greatest respect and deference to the trial court, that is not the position of the law. The document has some probative value for which some weight can be placed on it, or it does not. It is not the law that a statement ought to be subjected to cross-examination before value can be ascribed to it. So, you see, Randy, if you pick all the things that transpired, and I want to also read this, it's very important I read. A reasonably drawn inference requires evidential foundation, which in this case is lacking, because no evidence was led to show that the first appellant had no authority to act. The fact relied on by learned counsel, with due deference to him, are based on conjecture and speculation. It proceeds. The issue whether the first appellant had authority to act or not is a matter of fact and cannot be speculated upon. Randy. There's a position that the court states, so that at least you can take. It was stated that there can be no inference of guilt unless there are objective facts on which the inference can be made. If positive facts are lacking, as in this case, what is left is mere conjecture and speculation. In this case, by calling on the first appellant to open his defense suggests that he was only entitled to be acquitted if he proved his defense. That that is show that he had authority to act to the certified with respect, in my view, that was certainly wrong.